Good afternoon. I have with me Professor Erwin Schwella. He's the Dean of the School of Innovation at the Hugenote College in Wellington. And the topic that we are discussing with him is the municipal elections, which could be postponed after a report from former Judge Dikgang Moseneke, in which he proposes the postponement of the elections. The IEC, in the meantime, made it known that they are investigating the right ways that they can go about it. With other words, implicating that they accepted Dikgang Moseneke's report. And to make a little bit of sense about this, I'm talking to Erwin about this. Erwin, good afternoon.
Good afternoon, Isak, and good afternoon to your viewers and listeners.
Let's start off with the two possible ways the IEC can go if they want to postpone the elections.
Let's just put that into some context. There is only actually one way, and that is the constitutionally legal way. But in order to meet those requirements, there seems to be, in a very complex legal situation, and of course also complicated by politics, there seems to be two ways, which is, first of all, one has to go to Parliament and you have to go through the whole process, which is an onerous legal and political legislative process of, in actual fact, amending the Constitution. Now, to amend the Constitution is very, very strongly protected from meddling for mere political reasons. And that's also part of the debate we hear, that there is a reticence to amend the Constitution because it can easily be abused for future purposes. So that amendment will probably not, in actual fact, be passed, because we know already that it will most probably break down along the same lines in Parliament as the lines related to the disappropriation of land without compensation. So for those purposes, it is most probably impossible to go that route. The second route, which I am also not certain will hold legally, is to amend the Constitution. Well, not actually amend the Constitution, but to go to court and to ask a court, a competent court, to then make an order. And that order will have to be that the court orders that the IEC can postpone the election based upon an argument which says that this is such a crisis. And remember, it will have to be hinged around the aspect of it's not possible currently to hold a free and fair election. So those are the two options, and they are both quite onerous, and I'm not sure that they will be successful. And finally, for the moment, the issue is, of course, that the Constitutional Court is a court of last instance, so they can't go straight to the Constitutional Court. They will have to find another competent court. I am not convinced that they can go to the IEC, the court closely related to the IEC, which is the Electoral Court, because if they go to the Electoral Court and some party who feels aggrieved by the Electoral Court's decision, then in actual fact, they cannot have the recourse to the constitutionally mandated Electoral Court as a court of appeal. Or actually a court not of appeal, but a court of revision for the decision made by the IEC. So it's probably a high court and then following the way to the Constitutional Court. And remember, those processes take a long time. In the meantime, October is looming large.
So let's take it one by one. Let's go to Parliament first. What exact steps will have to be taken if we accept that the IEC is going that route?
there's got to be a sponsor for the legislative amendment of the Constitution. So they will have to find a member. It's possible in Parliament even for private member bills, or a party or political parties who will come to an agreement to submit to Parliament for consideration and acceptance a bill, which is an act of law before it gets formally promulgated as an act. And that will then have to go through all of the processes of public participation, through the committee systems in Parliament. There will be a lot of possibilities for political parties who are not in agreement to find ways on procedural matters to prolong the issue. However, if finally you get through that process, then you need a majority, which is an added majority. It's not a 51% majority. To amend the Constitution, you need a 66% majority. And that means that it's difficult to get that majority if there's not a lot of support for the particular legislation. And probably that is why they are not doing that. They realize this is just not going to work. It's just not possible. So therefore, their second option is the option to take it to find a competent court first, to take it there, to have all of the legal arguments which will be dealt with there, and then to hope that that court will make such a ruling and in actual fact command such an order.
Okay, so let's accept that both scenarios are impossible to get. What is the alternative there?
Well, then the legal and factual position is that the elections have to take place. That, however, introduces a new set of interesting dynamics, in the sense that the IEC, the Independent Electoral Commission, has probably as its main purpose and function the whole process to manage and administer the whole process of free and fair elections. Now, what we know is that the IEC would not have appointed the Moseneke Commission, would not have accepted that particular report and started a process to get a competent court to rule on it, if they thought, in their minds at least, that they can finally certify this as a free and fair election. So they already have serious doubts about that. Then I think the conundrum is, now there is an election because it hasn't been postponed, and the IAC says subsequently, well, we tried our best to warn you, you were not listening, and now we declare this election not free and fair. They've indicated that that is actually their opinion. Now, that then creates a serious issue, because on that basis, the election has to be reconstituted and of course held again. And that is probably where we might end up if this thing comes to the brink.
If we come at this point that we have to go to the polls on 27 October, but we can't have a free and fair election, what will be the legal position of all current municipals be?
That's another part of the serious set of considerations to take. If the elections are declared not free and fair by the IEC, which is their good right, and they will have to take into consideration the law and the objective facts, and they will argue it was not possible to campaign, probably voters couldn't turn out. Whether one agrees with that or disagrees with that is not the point. If they declare it not to be a free and fair election, then, and I'm working on the assumption here, then I think you may have, well, either one of two positions. It might mean that at least the current incumbency of the political groups, that is the councillors, could, and I'm stressing here, these are very intricate legal issues that one has to research, and advocates debate and judges decide over months on these things. but it could mean that all of those incumbent councillors are actually not legally in position anymore. So that's one possible scenario. The other possible scenario is that the IAC then may suggest that the current incumbency stay in place until the next election takes place, and that then means that they are legally still in place and can function as councillors. As I say, that is probably highly contested. In these types of situations, what is pragmatic and in actual fact practical do not really matter. It is all about, you know, the purpose of particular political parties and how people interpret this thing. So to make it very clear, there are two options here. The incumbency after that particular date on which the elections are not declared free and fair is advised, and it is accepted by a significant set of people. Then the incumbency remains legal and they can act officially. Or it might be that the incumbency is not legal anymore and they can't act officially, and then we've got further chaos, because that means that in some ways you will have to find a way of getting, in terms of the cooperative governance matters in the constitution, perhaps provinces getting involved and managing municipalities. That might be an option, because they can do that in terms of the whole idea of setting up administrators or in some ways assisting cooperatively. But it is really a hornet's nest of a huge number of intricate issues. The best would have been if we could just get the municipal elections to take place on the 27th of October, which seemingly is now under pressure, and we don't know which way that will play out.